Welcome to From Students to Licensed Professionals, Protecting Your Rights.
Welcome to From Students to Licensed Professionals, Protecting Your Rights with attorney James Kosnett. James has represented licensed professionals for decades, helping doctors, nurses, dentists, teachers, real estate professionals, and others protect their license, their reputation, and their careers when complaints or investigations arise. I'm Lisa Mosby, and today we're talking about what to do before responding to a professional license complaint. James, welcome back. I look forward to this conversation with you, sir.
Great, Lisa. Thank you. Me too.
Yeah. James, what does it mean when a licensed professional receives a complaint from their board, and how far along is the process at that point?
The process has been going on, but you don't even know about it. Someone's made a complaint about you. It could be justified. It could be totally unjustified. It could be someone you know you've had a little problem with, or it could be someone you had no idea. You thought everything was fine. It could be something recent. It could be something from years ago. And they've made a complaint to their board, whether it's a patient of a doctor or the family of somebody at the hospital that a nurse took care of, or a real estate professional's buyer or seller in a transaction, or even another professional sometimes of who's complaining about you to the board. You don't know about it. And the first time you usually hear anything is when you get a call or even a visit at your door from an investigator. And sometimes it's very surprising.
Could you tell me what typically leads to these complaints being filed in the first place?
Well, it's the perception by someone that they've been overcharged, or they haven't been treated properly, or they haven't gotten the care that they deserved, and there's something is bothering them or a family member, and they're bringing a complaint. They bring a complaint like the old days against you bring it with the Better Business Bureau, or you'd complain to the manager or something, or well, in this case, they're complaining to your licensing board, and the investigator calls you up and asks you, and the temptation is for you to respond right away, for you to answer the questions, or, oh, yeah, what are you talking about? Sure, I remember so and so. Yeah, it was this, it was that. Big mistake. It doesn't matter if you're innocent or you're guilty. There's nothing to be gained by immediately responding to this investigator. At best, you're going to get everything right in your memory the first time, and they will accurately write down what you tell them. But that's at best. That rarely happens. Usually, there's some things that you don't remember. There's things in your file that might even surprise you, a letter or an email or a contract. You should look at all of that first. Also, when you talk to the investigator, they're they can misquote you. They could get it wrong, accidentally, whatever. They could not put down properly what you're telling them. And then later that's going to hurt you when there's a case against you. And you say, well, doesn't it make me look more innocent if I just respond right away? Maybe I can save some money, avoid a problem, just speak up for myself. And they'll realize that I've got nothing to hide and I didn't do anything wrong, and they should just listen to what I'm saying and close their file and go away. That's not going to happen. You're not going to talk the investigator out of his or her investigation. They don't have the authority to listen to you and decide that, oh, you're really in the right. That's not their job. Their job is to gather the information on both sides and really, really to make a case against you, if truth be told. And if not make a case against you, at least to gather all the information. So they are not a decision maker. So there's nothing to be gained by speaking up for yourself. Well, if I ask, if what should I tell them? Tell them, be nice to them, of course, be charming. Hi, how are you? No, you caught me at a bad time, but my lawyer will get in touch with you. May I have your name again? Your contact information? My lawyer will be in touch with you. So you might say, well, doesn't that mean you're guilty? Your lawyer's going, no, it just means you're a smart person. You're a smart professional, a smart business person. It just means that you care about your license. You care about what you're doing to help people in the community and to support yourself and your family. If you care, you're going to have an attorney protect that license. And that's everyone's right. And believe me, in California, in the 21st century today, nobody takes that as any kind of consciousness of guilt. That's what they expect. And it's just like when the policeman stops you after 11 o'clock at night and you're driving and he's asking you how much have you had to drink and so on. You don't have to talk to him. You have the right to remain silent. We've all seen enough police shows to know that. You have the right to remain silent. Anything you say can and will be used against you in a court of law. Well, it's the same thing here. In these licensing matters, anything you say can and will be used against you. So let the lawyer get involved.
And James, when that first letter comes in, uh, what is the board actually asking for and how should it be interpreted? I'm kind of curious how professionals are expected to respond to these initial letters.
Okay, so like I said before, usually the first contact is a call or a visit by an investigator, but then eventually, especially if I'm involved, I'll send a letter of representation and I'll get in turn a formal inquiry. And if, for example, if it's a doctor, they might ask for all the medical records for that patient. That's fair. Or if it's for an insurance professional, they might ask for all the business records from that person in your office and what have you. That's fair. They're entitled to all of that, and I will provide it. You'll give it to me. I'll go through it and I'll vet it and make sure it's accurate and it's clean and it makes sense and so forth. And I will, of course, turn it all over. I'm not going to exclude any evidence. I'm going to give them all the evidence, but I'm going to see it first and we'll know what they've gotten. And the pages will be numbered and we'll have control over it. And I, in turn, will find out everything I can about the other side. Who's making the complaint? Can I have a copy of the complaint? Well, if I can't see their complaint, can I have a summary of their complaint? And quite often, the investigator will want to interview my client. Sometimes I'll allow it, and sometimes I won't. So you might say, well, James, do you have that right? Well, it depends on the board. Some boards, we have the right to remain silent and not to be interviewed. Others, we have to go ahead, but first I can see the file and I can see the contents of that file. A lot of times they say, well, we'll show it to you at the interview. No, I want to see it in advance. I want to see everything in advance. And then a few weeks later, what have you, after a reasonable time after, then we'll come into your office and allow you to interview my client. And so I protect the client in a way that the client just can't do on his or her own. What's going to happen, if I may go on. So what's going to happen after that point, after all the information has been gathered, maybe in 10% of the cases, it's dismissed or nothing happens. But usually, in most cases, the board will file what's called an accusation. It's like a complaint in court. It's very similar. It's an accusation, and that's where the deputy attorney general or whatever attorney it is now who's representing the board sets forth the allegations of wrongdoing and why the license should be disciplined. And they will mail it to your to your office address of record or your home address, whatever your address of record is, your home or your office, that's where it'll be mailed. So you should make sure that that address is always a current address, a good address. Okay. And then when you get it, of course, you give it to me and we request a hearing. We only have typically 15 days, give or take. It's slightly different depending on the board, but usually around 15 days to request a hearing. We request the hearing. We will get a hearing in front of an administrative law judge. Now, that hearing won't be for 6 months, often to a year. So what happens meanwhile? We do discovery. We get from the board all of the evidence that they had, all the complaints, the records, whatever they have to show that makes them think my client has done something wrong. And I share that with my client when it comes in and we discuss it. We go through it. We go through the whole thing. And then we, in turn, have to produce to them. We have to produce to them all our records and all our documents. If we have something that supports us, if we have a signed release, or we have a photograph, or we have a consent form that the patient signed, or we have maybe we have a letter of recommendation or some kind of great evaluation, whatever we have that we're going to use to put our best foot forward, we make copies and we send that to the board. So now both sides have exchanged documents, okay? So now what do? Now we talk about a settlement, okay? So maybe we can turn a revocation into a suspension, or a suspension into a probation, or a probation into a warning. Maybe we can get some lighter form of discipline, make some deal. They like it because it avoids the trial and it gives them a sure result. We like it for the same reasons. We save money, we get a sure result, and it takes the risk and the worry out of it. You can't always get a deal. I get a deal maybe half the cases, about half the time. Now, I never decide myself. Anything I do, I say, great, I'll talk to my client, I'll get back to you. And I discuss it with the client. The client's the boss. I put everything to the client, or he and she makes the decision on whether to accept the deal or to counter or to say, you know what, we'll go to court. We'll just let the judge decide. And we're very successful in court because usually the judge isn't as strict as the board. Usually the board is very strict and I'm very lenient and the judge is somewhere in between us. It's not like a criminal case where the district attorney is offering you maybe a sweetheart deal. But if you turn that down and you go to trial and you lose, you will have a harsher sentence. So you have to kind of make a tough choice. They have to do it that way in criminal court because if everyone in criminal court elected to go to trial, they'd be overwhelmed. They don't have the time and the space and the judges to do it. So they have to make a sweetheart deal and avoid a trial or make the defendant pay the price of going to trial if they should lose. But that's not how it is in administrative law. In administrative law, you're actually probably going to do a lot better with the trial than you will with the board itself on the deal.
James, when you see cases where a license is preserved versus cases where discipline becomes more serious, what factors usually drive that outcome?
They're not supposed to punish you. They're in this kind of a case, the standard is supposed to be the protection of the public. So even if you've done something wrong, but you could show that you're sorry about it, or maybe you were drunk driving or something, but now you're in an alcohol program and you're getting tested all the time and you're being clean and sober now for a couple of years or whatever the case may be. Uh, whatever we can show to show that the public is not better served by removing this person from teaching or from dentistry, but rather from letting them continue to serve the community, that's the person that's going to hold on to their license. We want to show that they acknowledge, if they've done wrong, that they've acknowledged responsibility and what they're doing differently about it. Are they getting therapy? Are they have they changed their way of doing business? Are they keeping better records? Whatever the case may be, depends on what the allegation was and what the alleged wrongful conduct was to begin with. But if they've addressed it, the stronger case I can make for going not easy, but appropriately, not throwing the book at somebody, not punishing them, but protecting the public and actually letting the public benefit by their increased service. So that's the key thing there.
Beautiful. I think that's where we'll leave it for today. And we appreciate your insights, James. Thank you.
Thank you.
Folks, that's it for today's episode of From Students to Licensed Professionals Protecting Your Rights with James Kosnett. We invite you to visit educationlawyer.org to learn more or schedule a free consultation. Thanks for listening, and don't forget to like, leave a review, and subscribe so you don't miss the next episode. We'll see you there.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.